Great, yeah. Thank you very much, Ione and the CEB team for inviting myself and Jason to present to you again today. My name's Simon Khinda. I supervise the corporate practice, the transactional practice for our firm, Khinda Wilson, or KCKW. I'm a New York and California licensed transactional attorney, originally educated in the UK. So about 17 years of practice on both the domestic, but also on the international level throughout the Middle East, Asia, and Europe. So broad global experience in various real estate and corporate transactions. And I'll be speaking to some of the corporate transactions and how COVID-19 has kind of impacted that. And I'll turn over to my colleague, Jason Brooks of Buckhalter, to briefly introduce himself, and then we'll get on with the presentation.
Thanks, Simon, and thank you again for CEB for having us. My name is Jason Brooks, special counsel at Buckhalter. We're a full-service law firm, but my practice focuses mostly in two areas. One would be real estate, transactional real estate. Our clients buy, build, own, and sell duplexes to 800-unit projects. They do mixed-use projects where the costs are $1.5 billion. We do hotels up to 450 keys, and then as well as office, commercial, industrial, retail, storage, pretty much the gambit, senior living. So we do acquisition due diligence through exit. So we're seeing a lot going on right now with COVID-19 and transactions. And then I also do mergers and acquisitions work. So prior to being a lawyer, I was an M&A analyst on the finance side. I've worked in private equity as well, and kind of know what our clients are going through from the other side of the table. So hopefully we can help get them through the transactions efficiently. And again, thank you very much for having us today.
Great. So with that, we will kick off, mindful of the time. We're hoping that we'll probably get this done in enough time to give time for questions, and we will take some questions as we go through the various stages of this. As the title suggests, we're really going to be talking about how COVID-19 and the pandemic has affected different types of transactions, what to look for in those contracts, if things are not in those contracts, the sorts of principles that can be applied. So from that perspective, we would start with a brief overview over the three things that have really been the hot topics. I think we were talking the other day, and it's funny, I think if you just Googled sample contract clause and put the first letter in F, I think force majeure jumps up. So this is really a hot topic right now, as many of you know, whether you're attorneys and receiving calls from your clients, asking them either about their obligations or their rights, their abilities to exit contracts and throwing force majeure, or whether you are yourself a consumer, a client, or a party to a contract and not really certain about how this is playing out. We're hoping to really put to bed some of the misconceptions, but also give clarity to these three important legal concepts of force majeure, impossibility and impracticability, and then frustration of purpose. We'll go through some examples of those, and then we'll talk about these in the context of both real estate as well as the corporate and business setting. And we will then move into some at the end, assuming we've got some time, on the CARES Act and some of the provisions in there as they impact the real estate sector specifically. So as part of the analysis that is done, when a person, whether it be an attorney or otherwise, when we're looking at the contracts or receiving the inquiries from our clients, it is important to first determine, and this will of course be the first thing we hear, is that, well, COVID-19 has somehow affected performance on the contract. It's directly or in a way impacting my industry and my specific business or my real estate deal or real estate transaction. And then as part of that analysis, we would want to consider first the contract. Our first point of reference is always going to be the contract, naturally. And so in any analysis, we're either going to see if the contract has a force majeure clause in it, and if it is, we're then going to start to look at the specificity around that. So I've identified here in the slide, as you can see, as you move down to the left side of this tree, some of the typical or common force majeure type provisions, pandemics, government actions, acts of God, essentially. And if there is not a clause, if there's not a force majeure clause in the contract, and as we'll see as we go through this, many times you won't have a force majeure provision in there, then you will look to the common law remedies. So, in the absence of force majeure, whether performance is impossible or impracticable, or whether the purpose for which the parties entered into the contract has been frustrated. So two separate analyses, starting with essentially the contract and reviewing that document first. So if we talk a little more about force majeure and COVID-19 and what's happened, one would expect, of course, that force majeure is certainly really falls in the definition of force majeure, the superior act, this intervening force, which has interrupted a person's performance on a contract. So parties, as I mentioned, have tried to rely on this, and then they've immediately assumed, well, if something like this has happened, because force majeure, as we all know, had been much more on the back burner of boilerplate clauses. And the first time people ever thought they'd rely on this is to believe that this was an opportunity to be excused from a contract. But of course, that's not what it is. Again, as I mentioned, and in the Black's Law Dictionary, it's a contractual provision which allocates a risk of loss of performance if it becomes impossible and impracticable, especially as a result of an event or effect that the parties could not have anticipated or controlled. So as I mentioned, this is a contractual bargain for exchange. So it's only going to apply, A, if the contract contains a clause. The clause will then need to give clarity, and you would want to look to see if that force majeure provisions, what does it define as a force majeure, and can COVID-19 be captured in there? And then to see if the particular obligations of the parties are in fact covered by the clause. So this is extremely important because courts are going to apply a test, given this is a contractual doctrine. In applying their test, they are not going to, and they've always been very, very hesitant to allow clauses which are very broad and catch-all provisions. They want to, as narrowly as possible, define what the force majeure event really was, and whether the particular event that a party is relying on is in fact appropriate for this. And it's also important to know, and we'll touch on this again throughout, but force majeure is rarely, in fact, or if ever, a reason to be completely excused from or terminate the party's performance under a contract. It is generally, if applicable, and if the appropriate procedures are followed, we would find it is generally purely a reason to rely on for delay of performance of an obligation. And Jason is going to touch on a couple of examples of force majeure clauses, and you'll see how that may interplay, for example, in the real estate context. But in doing so, and as you'll probably see from some of these clauses, it's also important to note that when a party relies on force majeure, there is a very specific procedure that one needs to follow. So you need to give the other side notice that you're relying on this force majeure. So about exercising the contractual right, and the provisions that are in there are going to be extremely important to rely on. So Jason, why don't we move to the next slide, and the first force majeure example you have there.
So these are some example clauses we pulled out of contracts that we use for clients. So the first one essentially gives you a break in time from paying the rents. So it does not excuse performance indefinitely, but rather it says that the force majeure event will be some sort of temporary period of time. It's not an indefinite period, but a finite period. And so in this situation, it excuses performance by the tenant, excuses the payment of rent during the time of force majeure, but you do have to give notice. And then once the restrictions are removed, rent is expected again. So in today's day and age, let's say that, in the next 30 days, I'm based out of Orange County, as is Simon. and let's say they decide to open up restaurants in the next 30 days, if this clause were in place, it would have likely excused performance for April and May, and then maybe part of June to go with part of March should have been shut down, but it does not give an excuse for the tenant to cancel the contract. And if we want to jump to the next one, we'll show something that's a little bit different that we put in other contracts, which is the clause that I bolded at the bottom of the screen. So this provision shall not apply to relieving the tenant from basic monthly rent. So we have different provisions. Sometimes our landlords want the CAMs still paid, right? And sometimes they want basic rent paid only. It kind of varies from transaction to transaction. I think, as Simon adequately put, it was an often overlooked clause that was thrown into a lot of contracts, and people were like, when is this ever going to come into play? Until we had a global pandemic. And now everybody's paying a lot more attention to it. I don't oftentimes see in our clients' contracts, whether they're buyers, sellers, landlords, or tenants, and generally we are on the landlord side, but even when on the tenant side, where it gives you full ability to cancel a contract. It generally stops your obligations under the contract for a period of time, and sometimes it adds that period of time to the end of your lease. So if you're paused for 3 months, it'll extend your lease by 3 months. Or it will require you to continue to pay certain items in the lease throughout the period, even if there is a force majeure. So things to pay attention and look out for.
Great. And so as we move on to the next one, I know we've already got a couple of questions, so we will come back to those questions shortly. So as I move on to the next doctrine and as we complete this section is when we'll try to address some of the questions that have been raised. So as I mentioned, force majeure, and as we discussed, is typically going to be found from a contractual perspective, and that's when it would be relied on. Now, on the flip side, and this is interesting for me because a lot of these legal doctrines have come from England from way back when, where I'm from. But frustration of purpose and impossibility, which we'll get onto now, are common law remedies. So this is going to be something that many attorneys, many parties are looking to, where potentially there could be a reason to terminate the contract and be excused from performance, unlike in the instance of a force majeure. And so frustration of purpose, the definition is there in Black's Law Dictionary, but a great case on this was a 1903 case in England where a tenant had rented a room from a landlord because of the procession of the coronation of Edward VII. And so the purpose was very clear. He was renting this apartment for this specific purpose. And then unfortunately, due to the illness of the king, the procession never occurred. And so even though, and then you see here now the difference between frustration of purpose and impossibility, and this was sort of the foundation of the birth of the frustration of purpose doctrine. But here, even though technically the parties could perform, the landlord still had an apartment that was able to be rented, and the tenant could certainly still rent that apartment. Well, in that time, the court agreed and said that the contract could be excused because the fundamental purpose for which the contract was entered was not simply because the tenant wanted to rent from a landlord a room, but was to view the procession. And given that that purpose now was not going to be available and not be achieved, therefore frustration of purpose would have been totally appropriate in that sort of a circumstance. So that's where it's sort of started. We saw the birth of this doctrine. And so if you see in this definition, it clearly says, doctrine excuses a promisor in certain situations when the objectives of the contract have been utterly defeated by circumstances arising after the formation of the agreement. And performance is excused under this rule, even though there's no impediment to actual performance. It's extremely important here, but frustration of purpose doesn't necessarily mean that performance is not possible. Again, slightly different to what we see in the impossibility context. Again, in the restatement of second of contract, section 265, we also see how frustration of purpose is applied and spelt out in terms of how it's used. So again, the party's principal purpose is substantially frustrated without their fault by occurrence of the event, non-occurrence of which was a basic assumption on which the contract was made. And so the remaining duties to render performance are discharged. So unless there's, of course, language in the contract which would indicate otherwise. So you could imagine in the instance where a cleaning party or janitorial service has a contract to clean a theatre after the performance of a live event, if we talk about in a more modern day context, well, if the performance has been cancelled, then the expectation in that sort of circumstance would be that the janitorial company would, of course, be excused from having to perform on that contract, because it would be a complete waste of time for them to clean a venue if, in fact, the very purpose they're there to clean is after the event actually took place. So that's where we will see the idea of a frustration of purpose. Again, slightly different to impossibility. Again, another even older British case, Taylor v. Caldwell in 1863, which is a Queen's Bench case. Here, plaintiff makes a contract with a defendant to rent Surrey Gardens, a music hall, for 4 days, and the music hall was destroyed by a fire. Seems, of course, obvious, but here we see how impossibility makes it completely impossible for the person to perform, versus frustration of purpose, which still allows someone to perform, but the issue with their performance is it was frustrating and not necessary. Impossibility, the hall here has been destroyed. So in the context of event contracts, for example, as we see a lot of those, or wedding arrangements or so on, and I'll start with event contracts before we go to wedding arrangements, but you would typically find that in the event someone has hired a venue during this particular time, and of course we've got shelter-in-place orders, government restrictions on public gatherings and so on, it's going to make it impossible for either party to perform, because the expectation there is that you could hold this event, a gallery showing or otherwise, and now that's not going to be permitted. So impossibility would be the appropriate doctrine there. Impossibility is slightly different to sort of the sister doctrine, which often gets referred to, which is impracticability. And impracticability, again, you would have performance would still be possible. So in impracticability, performance would technically be possible. However, there has to be a showing that it would be extremely burdensome. So extremely burdensome for them to perform. And even in that context, the court is going to look at, what we've seen is courts will look at, has the party who wants to invoke these sorts of doctrines, certainly impracticability, well, is there any other way for you to perform on the contract? And if so, we probably won't apply impracticability. So courts generally, when they impose doctrines, as we know, and for those who are not attorneys on this webinar, courts are going to try to keep the parties as closely as possible tied to their contractual obligations, certainly looking at equitable remedies where appropriate. But if there are alternative ways for events to happen or otherwise in that context, then we're likely to see that courts are not going to have this blanket, let this be the floodgates open, essentially, for people to start terminating agreements unnecessarily, when potentially there are other means by which these things can be performed. So it's really a very factual analysis when looking at a contract from both a force majeure perspective, or a very fact-based analysis as it relates to impossibility and impracticability, to see if, in fact, a party can be relieved completely, or whether there's really just going to be a delay in someone's performance on a particular contract, and we're just going to sort of suspend the services. So it's always about, can they perform, impossible to perform, impracticable. And loss of profits, let's be very clear on this as well. Simply because a contract isn't profitable, is not of itself going to be enough, right, Jason? I think you'll agree that's
it's not enough to cancel, right? Like that's your error in negotiating a non-profitable contract, right? Ultimately. And I think in this situation too, right? Like some good examples people have asked are like Coachella, right? The group that rents the polo grounds for Coachella, right? No group gatherings were allowed over 10 people, right? So Coachella had to get canceled. So maybe Simon, you walk us through, let's just say Coachella or the Eagles were supposed to have a concert at the Forum. Why don't you talk us through which contract doctrine might be better at, let's say Coachella, to, cancel that contract for that event because it only happens at a certain weekend or 2 weekends every year. Right,
exactly. And so in that instance, you'd probably look at something like impossibility because they are going to be prevented from hosting the event in the first place. And they're not going to be able to gather in that sort of a context, right? I don't think we'd look at impracticability because even though they could perform and profitability, I think there you'd have an issue, but it's impossible for these people to gather in the first place. So if they can't perform, and that event couldn't necessarily, unless, of course, I mean, the other side to that argument would be, well, could Coachella be moved to another weekend when these bans are lifted? Right.
And the question becomes if you knew that specifically the property was rented for those 2 weekends for, it kind of gets back to the frustration of purpose as well, where they rented the apartment exactly for the parade date. The parade date didn't happen. So therefore they rented it for those 2 weekends just to host their music festival. Right. And that's now frustrated because they couldn't have gatherings over 10 people. So.
Yeah, absolutely. So, there's always that factual analysis depending on the type of circumstances. Are there alternative means? But then looking at what the purpose was. So all of these, we've seen a lot of this where parties should expect some of these events are foreseeable. And I think certainly after COVID-19, you'd almost think nothing's off the table in terms of foreseeability at this point on a go-forward basis in terms of contractual negotiation. Not only do I think force majeure is going to be the first clause that's negotiated in a contract all of a sudden, but at the same time, we will see that there should be an expectation that things could come up that really hinder performance. And, unlike back in the olden days where travel was much more difficult, so that, the spread of disease or illness in one jurisdiction, one country may not necessarily affect other countries, things spread a lot quicker now. The movement is much quicker. And so, it really is going to start to be foreseeable in terms of these sorts of circumstances on a go-forward basis, I think, is what we'll find. I think at this stage, Jason, I did see an interesting
I'd love to answer this question really quickly. There was one about the bold typeface and the difference between, essentially they said, well, it essentially just excuses the clause above it. So that's actually not the case. So oftentimes in these larger commercial leases, it requires, let's say the tenant is Baja Fresh, right? I'm just going to pick somebody. And it requires Baja Fresh to continue to operate a restaurant on site as part of the lease, right? So still requiring them to pay rent is one thing, but it is not requiring them to operate the restaurant, right? There are other segments of the lease where right now that would be a perfect clause right now to look at for restaurants, bars, right? You're still required to pay your rent, but the other terms of the lease as it pertains to operating a business and hours and notices of regarding operations, those can cease, but the rent expectations oftentimes are still expected, whether it's base rent or CAMs or something like that. So that I just wanted to make sure we answered that question because there are other parts of a contract that the performance is actually excused.
Right. Yeah, exactly. And this is important. And we've seen some of these. I have a current one where exactly this is the case. It's obligations excused other than the performance of the payment of rent. And all of a sudden it becomes much more the commercial negotiation. I know we're going to be getting into that. There was another question, which I think we're going to touch on later about, I don't know if you have any thoughts on this right now, but it's something we'll probably address later on, regarding eminent domain provisions. This is a really interesting way of looking at eminent domain. I saw it pop up.
It was actually really thought-provoking. So Howard, I think that's a great question. Eminent domain, though, I mean, you could probably argue temporary eminent domain, right? But not full eminent domain to cancel the contract, right? Because if you can go back to business in 3 months, you might be able to use eminent domain as part of your negotiations to get an abatement or forgiveness of rent. That's actually a fairly interesting argument, because you can argue, let's say that the government took your ability to do business, but I do not think it will be an indefinite taking of your business, which would be the full execution of eminent domain. I think it'll be a temporary taking of your business.
Right.
If it were to be approved, I think or if it would be a valid argument. So.
Yeah. And it's very interesting. I mean, granted, California does permit temporary takings, but at the same time, this is such a new area, and we don't really have, I think, the sort of case law for this to certainly say, I think it's a great way to look at it, and a novel way in terms of how it would play out. I think, that would be, I'd also be interested. So we'd certainly look into that and come back to that question.
And Howard asked a quick question on top of that. He said, so some eminent domain clauses do require termination. I think, though, that the argument would still be that it is a temporary taking. I don't think you could use it to invalidate an entire contract. But there is something that got proposed in the legislature that we'll hopefully talk about at the end regarding Senate Bill 939 yesterday.
Yeah, we'll get into that.
Create different cancellation issues. So we'll keep moving through.
So let's move on to now the impact on real estate deals. And Jason, I mean, this is your piece, so why don't I let you go on for here, and I'll go through the slides.
Sure. So, I mean, I think the first place we need to start is looking at the lease. You need to just come through your lease and figure out what your options are, right? First, if you have a force majeure clause, you need to stop and analyze it. What does it excuse you from performance of, right? As I said, oftentimes in our contracts, you're not excused for an indefinite period. You're either excused for a temporary period, or you're excused of certain items, but rent is still required. And if that's the case, then you need to then turn to different options. But let's say you do have a force majeure clause, and it does allow you to, it doesn't actually say a specific time period or that you still have to have certain obligations. I still think that it ultimately would be a temporary suspension, not a full reason for cancellation. We'll get into 939 later, but right now I think, force majeure clause stepping in, I think, it gets into different issues as well with people regarding insurance and business interruption, which we might be able to talk about at the end. But even if your building is contaminated, it's a week, maybe 2 at the most to clean it. So you'll get that extension. We did have a client that had a large office tower that did have a contamination. It was expensive to clean it, but they did get it cleaned, and it took a few extra weeks. So I would think that during that time as well, you would be excused from performance. So if we go to the next slide, as it pertains to other items from rent abatement, right? So I think temporary impossibility or frustration of purpose might be better off as an argument for an abatement or for an extension and not having to pay your rents during a certain period of time. The one thing I will tell you, working with a lot of landlords right now, is a vacancy does not look good to your lenders, and vacancies might take a year or 2 or more now to fill. So if you're representing a tenant or you're representing a landlord working with a tenant, I would highly recommend trying to find a way to make it work for everybody. Abatement might work and abatement might not, but extensions are a great opportunity right now. Most people are getting abatements and then adding months or executing extensions onto the end of their loan. While you think it might not be, it's a short-term detriment, but when the lending market comes back, if you have longer-term leases, it will make it much easier for your client as the landlord to refinance their loan and then give them some safety if their current lender is frustrated with their inability to pay. Quiet enjoyment's an interesting one, right? The contaminated building makes sense, so you're going to get a temporary delay there. If you're a non-essential business, at this point, right, most businesses are finding ways to be at work in some way or another, right? Like restaurants are still operating. There are a lot of exemptions, and you can make a pretty strong argument for many things to fall under essential business. But ultimately, the property is still available, and it's just for a temporary period of time, you're unable to access it. So that's just something to keep in mind. Again, I think force majeure is a good opportunity potentially to get a pause in certain payments, but you might actually want to turn instead to impossibility or frustration of purpose. It probably is a stronger argument with your landlord.
Right. And just on that note, Jason, I mean, are you seeing that when tenants and landlords are sort of negotiating a rent abatement, I think you briefly touched on it, but just whilst we're on the slide, where people are looking at agreeing to rent abatement, are you then seeing that the result of that is going to be an extension of the lease by the number of months that the rent is abated?
So we've seen anything from an extension for the number of months. We've seen people actually, if the owner feels comfortable regarding the tenant's ability to return as a successful business, we even have people taking extension options or extending the lease for longer than just the amount of months without the rent abated. It gives comfort to all parties, and it's just a normal negotiation. But look, it's hard to move a business, and it's also hard to find new tenants, and it'll be even harder to find new tenants. So we are seeing a lot of renegotiation or extensions added on, and it's to the benefit of all parties ultimately at the end of the day. So vacancies also affect your loan. Besides the cash flow perspective, many commercial loans have occupancy requirements, right? And then you breach covenants if you fall below a certain level of occupancy. So it also is in your best interest to work through it.
Right.
So we'll jump down to the next part, which is the landlord's perspective from leasing. There's likely going to be delays in delivering new space. Build outs, if the construction stopped while construction is considered essential. We have had people stop construction. And so that will just cause an extension. Oftentimes, right, if you have a must be delivered by date, people are working with one another to get an extension on the space and delivery dates. So, it's all about communication. I think ultimately at the end of the day is being open and communicating. That's where we've seen the best results. So, and then the other issue really quick too has to do with your lenders. If you are the landlord, right, because you're still the borrower, and unless you are a multifamily landlord with a Fannie Freddie loan, you have no guarantees on, abatements of your payments. And so right now, the first thing to do, and I told clients to do this 2 weeks before the stay-at-home order started, was call your lender and say, this might be coming, and work with them. The clients that did were extremely happy. The clients that waited realized that everybody called their lender on March 15th or whatever day it was.
Right.
It took weeks to hear from your lender, right? But when you were proactive, it was a better situation. And so we have had some success as well working out different renegotiations of the debt structure with the landlords and the lenders. It could be the same scenario that you're seeing, Simon, with landlords and tenants, right? Where they're just going to add 3 months of payments onto the end, and your loan term's extended by 3 months, right? There's different things that people are doing in order to assist their clients with the lenders. But ultimately the lenders right now too don't want 20% or 30% of their loans on their balance sheet being in default or non-performing, because when they go through their stress test, right, it ultimately turns into a bad scenario for them as well. And so I think it's to everybody's mutual benefit to find a way to work through it.
Right. And I think, as much as we talk about these provisions, force majeures, impossibility, impracticability, whilst these all become legal, terms and strategies that one can use, I think what we will see, much like how we rarely see cases go all the way to trial, what you're really seeing from a practical context is using these to be able to collectively figure out the new deal, right? To kind of negotiate these things, as you said, like with the lenders and so on, landlords and the rest of them.
And I will tell you, we've been doing we have clients purchasing apartment buildings and other things during this time, as well as like landlords doing leases with tenants. There are new clauses that are getting thrown in just because of COVID-19, like general pandemic clauses, et cetera.
Right.
So that when this situation pops up in the future, we're not sitting here scrambling, trying to figure out what the right thing to do is.
Right.
So kind of like Simon, you probably saw this like starting last year when there was potential of repeal of Prop 13. Some landlords and triple net tenants were talking about when they were doing extensions, what would happen in the leases should, the property taxes skyrocket all of a sudden from reassessment.
Right. Exactly. So I think this kind of briefly speaks to, again, the sort of lease workout options. So some of the things you're looking at and seeing.
And I think we covered most of the items on
Yeah.
this slide, but again, it's really just working with the parties to find the best solution, because everybody benefits by working this out. Everybody benefits by having tenants still occupying your space, by having payments come in, by having stability. So
Right.
purchase and sale, and this is the one where I think we've seen things get a little bit crazy. I think the issue is now is if you walk into a purchase and sale during this time, you could not make the argument for force majeure or frustration of purpose or impossibility, right? Because you already know the scenario that you're walking into and buying the property. We have a client that's about to put under contract a $25 million apartment building in Texas. And he asked me today, can we put in these things? And I said, look, we can, but if you're going to argue them after the fact, you already had knowledge, right? Like you already knew everything was going on and you made the decision to buy the building. The issue really comes up is when you went into contract before this happened, and especially where your deposit was non-contingent and had potentially been released out of escrow. Now, what do you do? In reality, you can ask for an extension. We've had a lot of people ask for extensions. Most sellers are really happy that the buyer still wants to buy the property at the same time, right? So if you just want an extension, I think on closing, they'll happily give it to you. We have seen some retrades, some substantial, some not so substantial, some as big as 20%. Probably the average is 5 to 10 when people ask. So that's a possibility as well. Going in, if you have a financing contingency prior and that contingency hadn't been removed, it's probably your best way to cancel, especially on the commercial side, because the commercial lending markets, unless you're doing Fannie Freddie small balance loans, are pretty non-existent. And if you are, I saw a loan get retraded from 90% LTV on a commercial deal to 60. It went from non-recourse to recourse, the rate went up to the point, and they needed 4x the amount of reserves that they had prior. Right. And so it's a difficult time. But getting in the inspections, I think the biggest issue you put up inspection, Simon, is not only inspections, but it's also appraisals. You can't get into units or you can't get into certain parts of the property. So you're appraising based on comps, which becomes a lot more difficult. And you're appraising from the street corner instead of being inside the building. So appraisals are difficult as well. Notarizations, they're still getting done. I heard of somebody the other day notarizing docs where the notary came and put them on the doorstep and watched the people sign them at their front door from 7 feet away, put them back down, and then they went and took them to get recorded. So
right. Yeah, definitely. I hear you. And in light of this, again, in the purchase and sale context or even in the real estate context, I know that CAR have, for a lot of the real estate brokers and agents, have released various forms in response to it. So maybe we could briefly touch on some of how CAR has dealt with this in terms of helping people through these transactions.
Yeah, so I'll jump into them pretty quick because I want to make sure we have time to get to everything else. So the CAR came out quickly with a coronavirus addendum. It essentially was a punt on their part, not taking responsibility or accountability for stuff. But what it really does is it explains how COVID-19's affected real estate. And then it creates unilateral cancellation or extension opportunities for the buyer, most importantly, with full return of deposit. So I had seen deals that had gone where the contingencies had been removed and then COVID hit and people were asking for this sign. And the sellers ultimately thought they could still keep the deposits. So they signed this just as an understanding for an extension. And then they realized after the fact that they didn't get to keep the deposit when the deal canceled. So that's the big thing about this addendum. If I was representing a buyer, I would require it right now. If I was representing the seller, I would fight really hard to not have it used. And then the second document, the notice of unforeseen circumstances, that's essentially you letting the seller know that you're executing your rights under the addendum or amendment to cancel or extend the contract. It is unilateral, but you are supposed to require, it does require verifiable information of unforeseen circumstances. So I could make a strong argument today that if you went into a purchase agreement right now, you should know what the situation is. The one area where we're seeing real difficulty is because everybody's so excited about the residential mortgage market because rates are low. But the issue is that the jumbo loan market is fairly non-existent. So if you get over a certain purchase price, but people don't always know that, right? People are like, I got pre-qualified 4 months ago. I know I can still buy the house and I really want it, but then that's the issue is an unforeseen is because that market is just not there. So that's the one thing that I would say be aware of. And then if we jump to the next slide, if you are a broker or you're going to look at a house, there are, different listing requirements now regarding protecting the home for coronavirus. And so those are in the broker will ask you to sign the amendment or addendum to the listing agreement. And then as buyers or prospective buyers enter the property, we had it happen today, everybody's required to sign this amendment that states essentially, I'm not sick. I haven't been sick in the last 14 days. And it's just an acknowledgement that I'm not going to contaminate the home to the best of my knowledge, right? Because if you're asymptomatic, you don't know, you might be sick and it hasn't shown symptoms yet. So those are the main parts of that.
Before we move to the next one, there's a question that's just come up. So maybe you can quickly answer this question. I know there are other questions and we'll get to those later on. They'll be more relevant later. But a question was asked, the car residential lease requires tenant to permit showings for sales by landlord with a 24-hour notice, probably can't be enforced on an unwilling tenant. I think that's exactly what this inspection form is intended to deal with, those sorts of circumstances now, right?
Correct. Yeah. Technically you still need to they'll give you the notice and you still need to show the house if it's for sale with the tenant in there. If you do have a tenant that's uncomfortable, that becomes a discussion, but that is the point of this addendum, is so that the people can say, look, I'm not sick, and walk in and see the property. They're still requiring like all the normal governmental requirements. So masks and everything else. We actually had the agent today provide hand sanitizer. They brought gloves for the people walking in. They brought additional medical masks. They did a really great job. But no, I think you'd still, as a tenant, have to honor it. The question becomes if you don't open up the house, but that's the point of the amendment at the end when you're entering, is to try to eliminate liability at least.
Right. And then loan documents, you touched on this briefly before, but perhaps you can just kind of circle back to this, right? What you're seeing in the loan context.
Yeah. And I'll just high level touch on all three. Ultimately, it's not a reason to cancel your debt. Your loans are still due and your loans are still payable. I do think that more of the frustration of purpose argument is the best to get an abatement on your rent, or on your loan payment. I apologize. On your loan payment, just say, the purpose of was to own a property that was operated for a specific reason. The purpose has been frustrated because the property can't be operated that way. I think it's the strongest argument, but ultimately, the loans are still due and you're just asking for a forbearance during this time period. The bigger banks have seemingly been the most willing to work with people. The ones that are struggling more are like private debt funds, which borrow money from people to lend to you, and they have investors that they need to pay back. So ultimately, though, no one wants a non-performing asset. And if you can go 90 days as non-performing and get back to performing 120 days later, it's probably the right way just to work it out with the different.
Yeah, absolutely makes sense. Again, in the interest of time, I know there are a few questions that have popped up, which are very fact specific. If you don't mind, we're going to go through and try and complete the presentation, but we will answer all of those questions. If not at the end as a Q&A, even if we run over a few minutes, we will do it in writing to you anyway. So we will respond to your questions, even if they are not addressed verbally here. And those questions, Q&As, will be made available to everyone that's participated and registered for this. So I don't want anyone to think that they're going to be ignored. I'm going to briefly touch on how this has now impacted the corporate deals, the business deals, and also corporate governance. It's really interesting how this is looking. So first sorts of contracts that we often see: supply production contracts, impossibility, as we discussed before, a doctrine that would typically apply and it would excuse the non-performance as long as the non-performing party can establish these three factors: that the unexpected event occurred, the agreement was assumed that an event would not occur, and the unexpected event made it performance impossible. So an example we've had for people in the manufacturing and supply space and distribution space, and we've got clients that are in that situation at the moment, because of government orders, or if a government in fact instructs and requests a factory to essentially pivot and switch their business such that the factory can be utilized, or the location can be utilized to help prevent the spread of COVID-19 and manufacture a PPE or other such products for that, then that company's non-performance for other production contracts is likely to be excused because it's going to be impossible. So much like the government ban, prevent and gathering, making it impossible, in the same way, and we have seen this, we are having these discussions at the moment with a couple of clients that are facing this sort of a situation. Again, just a note, just because it might be a little more difficult, just because there may be greater expense in performing on a contract, doesn't mean that that contract is impossible to perform. You may have an impracticability issue there, but it's really going to have to be a demonstration of extremely burdensome. So that's something to be mindful of.
So Simon, can I ask you, for your clients, if they're supplying something to a like a final party, but it's impossible for them to get shipments in from China because certain shipments are stopped, would that be at least an argument that they could make to delay or stop?
So I think for delay, certainly, whether it will allow them to completely get out of the contract, it could be an argument. I think one of the issues is we're already starting to see now restrictions being lifted, right? And so because we're starting to see restrictions being lifted, and there was a famous case on this. I think the case was Kuhn 7200, but that was a case where a contractor, a party contracted with another vendor, and they already, during the time, the risk, the effects, and at that time it was terrorism in the Gulf War, was diminishing. And so they said it shouldn't really be impossible or excused. This was sort of known. So I think it could be an argument whether it delays or completely gets a party out of that contract. It would sort of depend on what the term of the agreement is and so on. Event contracts, we've already touched on this, but there was something really interesting that came up, a recent case. So I wanted to really touch on it from this perspective. We've got event contracts where they're for a very specific time, a very specific day, and they're now not able to be performed because of these shelter-in-place orders. So you'd expect impossibility to allow the parties to terminate, and this partially answers one of the questions in the Q&A tab, allows the party to get out of the contract and get their deposits back. You would absolutely expect that. Now, on the flip side, StubHub, the largest secondary marketplace for seller tickets, their big thing that StubHub had was this fan protect guarantee, which essentially said that they guaranteed that if there was an issue, fans would get their money back. Now, very sneakily, what StubHub did, I think it was on March 25th, if I'm not mistaken, they took out this fan protect guarantee from their clause in their terms, and they said we'll be giving coupons, and I think up to 120% of the value rather than cash back. And of course, people were not happy about this at all. And in fact, in Wisconsin, in the federal district, I think in the Western District, class action has been filed because of it. So we're going to see some very interesting litigation coming out of how these contracts are going to work and what's going to happen with them, and what parties are or not going to be able to do. So that's event contracts. M&A deals. Despite the circumstances and the economic climate, we're still seeing a lot of activity in M&A. People are still buying and closing. But with that being the case, there are also those people that are looking to get out of their M&A deals or renegotiate their terms, right? And one thing I'll tell you, and one thing you will see is there is very rarely a force majeure provision. I can't recall the last time I saw, in fact, a force majeure provision in an M&A contract. So unlikely you're going to find that. But what we have seen is people relying on something which is very prevalent and very common in an M&A deal, which is what I call the Big Mac, the material adverse change, right? And this is extremely important because here we're looking at, was the valuation, does that need to change, and how significantly can the valuation change? Because the target company that we were acquiring, its financials, not and it can't be broadly speaking as it impacts the industry as a whole, right, of the target companies in. That specific target or that specific and its group of subsidiaries have to specifically have been impacted economically as a result, wherein you could say there has been a material adverse change in the business from the time we started this deal to down the line in the deal. And as a result of that, we could potentially look at renegotiation or termination of the contract. But from a litigation standpoint, we've never seen this litigated. I'll caveat, certainly in Delaware, we have not seen MAC clauses litigated until, and I believe it was in 2018, was the first time, and it was the Acorn decision, is the first time where, and that's the 2018 Acorn decision in Delaware, where the Delaware Chancery Court actually agreed that in that specific circumstances, there was such a material adverse change that it allowed the parties to terminate the merger agreement. And that case was Acorn versus Fresenius. So force majeure unlikely to apply in M&A deals, but certainly material adverse changes is an instance where parties could be looking at either getting out of it or a renegotiation or otherwise. I mean, on that, I know you get involved in some M&A work, Jason, but I think you'd agree, right? This is something we will see and people looking to rely on.
I agree, and I think that's kind of part of how people have canceled already. If they did cancel deals, was the drastic change in valuation or the business itself. But like you and I were talking about earlier with our clients, right? Just because the value went down, they're now looking at, okay, the business still has some assets that we want to buy. It's just less in value. The seller probably still needs to or wants to sell. So the parties just have been renegotiating prices and terms rather than, or just putting a pause for 90 days on valuation before picking it back up. So. Right.
So my last point on the corporate stuff. So aside from contracts and business agreements, corporate governance is hugely affected by this as well. Certainly this would apply to many more of the larger companies, some of the public companies and so on, but certain examples where corporate governance, we always talk about corporate formalities, where we see it could be impacted. A company is going to have its set of bylaws, and in the Delaware Code section 110, there is provision for emergency bylaws. So in the event the bylaws of a company don't provide for certain actions to be taken, and now we need to look at amending those, the Delaware corporate law, general corporate law, provides for emergency bylaws. So they've really thought about this and how this is going to play out in these sorts of situations as a result of other threats, terrorism acts and so on that have provided for this. Locally in the California context, consent to virtual meetings, very interesting again. California law requires all shareholders to consent to the holding of virtual meetings. And that's captured in Section 20 and Section 600, or those chapters in the Corporations Code. But very recently, March 30th of this year, the governor dispensed with this requirement and said that you would not need the consent of all shareholders to hold virtual meetings as a company, and that in fact, if it's not provided for in your bylaws, you would still be able to hold these virtual meetings. Something not many people want to think about, but do need to be thinking about. There are unfortunately a lot of people that have been getting sick, people in senior positions in companies. So succession planning is something that companies should be thinking about in the event that this drags on for further, or if a party or someone very important in the company with a specific officer, may be impacted. You'll want to be looking at succession planning and building that in as well. So there's another corporate governance thing to consider. And then finally, boards have fiduciary duties and consider their oversight roles, and they probably need to switch gears and look at what are they as a company doing now with respect to the current situation, emergency succession, cybersecurity issues, liquidity concerns, as we talked about, Jason, and staffing, and just kind of, bringing the staff back. How do we ensure workplace safety? So the board's traditional role, we're likely to see, and boards need to be looking at this, slightly changing in terms of their priorities, but always documenting this as well, as they kind of fulfill their duties. We don't. I'm mindful of the time, so we'll touch on these two very briefly. Key drafting tips.
We talked about most of them, Simon. I think, things to be aware of. And I think I would like to give you a little chance to touch on CARES Act and real estate as well. So people can see the slides after, but really just be mindful of the clauses now. What makes it work? What are your responsibilities and rights if there is force majeure? And, now solutions, right? What are you going to do with tenants? What are you going to do as a landlord? How are you going to abate rent? Terminations, like what do the pauses look like, and what are the responsibilities of the guarantors? So I think it's just stuff to keep in mind that we've already talked about. And Simon, really quick too, on what you're just talking about in corporate governance. I know you work a lot with family businesses, privately held, like closely held businesses as well. Succession planning has got to be most important. I mean, it's important for everybody, but definitely important for them because people are either sheltering in place together, small family business, or where the family is a small, tight-knit group. Having that in place in case people do get sick is probably something you guys are working a lot on.
Yeah, absolutely. And I think, we also have an estate planning practice, and it's why we've seen such a huge uptick in the estate planning, because everyone is really starting to realize, and it's brought home the vulnerability and the issues and how quickly this can turn for people. And, with that in mind, people really do need to be thinking about this is not just applicable when we talk about corporate governance. This is not just applicable to the big public company. This is very applicable to the small, closely held family business, where they have to think about those things. Otherwise, you're going to essentially have, even in a small context, business paralysis, right? So yeah, absolutely, we're seeing that. Again, I think we touched on this as well, Jason, just in terms of drafting tips around purchase agreements and so on, and sort of building some of these contracts in. This actually goes to a question we got, which I do want to answer afterwards. But a question that was posed is that, given frustration of purpose, for example, is a common law remedy, do we foresee contracts being able to be drafted where almost that purpose is built into the agreement without having to go to argue in courts? And I would say, and I think you're going to say it, but my view is, parties are free to bargain whatever they want, and I think you will absolutely see this now. People are going to try and capture everything at this point, and contracts can get a lot bigger all of a sudden. I don't know what your thoughts on that, Jason.
I would agree, right? You're free to bargain as you see, and I think people are going to start putting in a lot more detail into certain types of contracts.
Yeah, absolutely.
And I think if just really quickly on that drafting tip for purchase and sale as it pertains to real estate, your financing contingency is unbelievably important right now. So just because of the loan market, that's the most important thing, and making sure you have enough time to get your debt in place, whether it's multifamily, residential, commercial, anything. So.
Yeah, and so that interplay between the financing contingency and then the force majeure and unforeseen circumstances, you may have had your loan in place at the start of the contract, and all of a sudden the wheels have fallen off, and do the debt ratios change, for example? Is that going to help, right? So absolutely, you could see that happening. We only have a few minutes, and the slides will be issued, but we really wanted to touch on three as they relate to, I think, primarily real estate. The CARES Act, in Section 4023, does provide for, in the residential context, forbearance of payments. So if there is a fine, as long as the lender is a federally backed lender, essentially, then a forbearance of payments could potentially be available if you can show that there's financial hardship, right? So certainly, that you could get 30-day extensions, with extensions beyond that for a total of up to 90-day in forbearance payments on their loans. So that's something that is definitely provided for on there.
And I think the government will continue to push it if things are delayed. The Fannie and Freddie will continue to work with you. So
yes, yeah,
FHA, those kind of things on single family.
Yeah, exactly. And now in the lender context, of course, and loans, foreclosure moratoriums currently in place, broadly speaking, as well as the state level. That's covered in 4022 of the CARES Act. So if for that period a servicer couldn't initiate a foreclosure, so it was 60 days from March 18th, I believe. And I think, again, we will see these things being pushed out as this drags further.
Also, by the way, keep in mind the courts have to be open for foreclosures to work. So
yeah, so from a practical perspective, you've got that issue as well. Yeah. We have gone just to 2 o'clock already. If everyone's okay, we'll go for another couple more minutes. We'll finish this up. Something very interesting came up last night, which Jason and I want to touch on, which hugely impacts anyone that's involved in commercial real estate. It's not on the slides. It was kind of hot off the press. So we talk about eviction moratoriums, which many people are familiar with, and there are, which the CARES Act, again, provides for. And there are, obviously, the Judicial Council has provided for its own set of rules where counties or cities have not imposed or the city's not put their specific eviction moratorium in place in the residential context. But let's talk about SB 939, Jason. I know you're pulling your hair out when you saw this last night, so I'll let you have the pleasure of this one.
So just keep in mind, there's been 2 bills that are introduced up in Sacramento, one regarding commercial properties and one regarding residential properties. Let me put this caveat in place. I think that they are both unconstitutional. But we will talk about them really quickly. Before I jump into 939, SB 828 is regarding multifamily. Some of the things include automatic 25% reduction in rents, all landlord tenants across the board on multifamily, ability of the courts to change contracts unilaterally between landlords and multifamily tenants. There's issues regarding nuisance tenants and evictions and 3-day notices, and it's not constitutional. If it were to even get close to passing or does pass, I think an injunction would be filed pretty quickly. And if you are representing a property owner or developer, just know that you, as well as Irvine Company and a bunch of the other big people, are on the same side on this one. And so there will be a lot of dollars spent lobbying as well as marketing against it. So just keep that in mind. SB 939 popped up pretty quickly this week. And essentially it says that you cannot evict a commercial tenant in the state of California or serve even the notice to terminate tenancy and evict until a full year after the COVID order is lifted in the state of California. We can talk about legally why this is unconstitutional. There's a handful of reasons, but I'm just going to run through really quick and just tell you guys my thoughts. If you served a eviction notice prior to the proper time, a $2,000 penalty to the landlord. And I think the thing that makes it hardest is the worst part of it is if you were a restaurant, bar, entertainment venue, and you can show a decline in revenue by 40% after the moratorium is lifted, and from your pre-COVID numbers due to a reduction of capacity of 20% or more, or 25% or more, you have the ability to renegotiate your lease. And if you and the landlord cannot come to a mutually satisfactory new lease, the third party guarantees will expire and you can cancel the lease and all you have to do is pay 3 months rent. So that's just stuff to keep in mind. If your clients call you in a panic because stuff gets sent out and they read it and they don't know what's going on, something to keep in mind. They are unconstitutional. I do think that there are a lot of people up in Sacramento trying to garner votes for the upcoming election for themselves or from their constituency for themselves or their party. So just keep that in mind. And they're not constitutional. They cannot come in and cancel your contracts. And so, ultimately, I think everything will still be in place. But I think the big takeaway from what Simon and I are seeing is have the parties work together, talk to your clients, find a creative solution, whether it's M&A, real estate. It's in everybody's best interest ultimately.
Yeah, great. That concludes our presentation. I know we still have people on here, and I thank everyone really for their patience and hanging around for the rest of this presentation. We have a few questions in here that I think it would be nice to get to. Again, for some of the very fact-specific ones, we will email you about them. but a couple of interesting ones, Jason, that have popped up in the Q&A if you want to look at those. I'm going to address the one question, and it is, a buyer agrees to buy a purchase a food van before the pandemic affected the purchase. After the pandemic, obviously all venues are closed, so buyer no longer is able to use the van. Can he demand rescission? Under which doctrine? What remedies do you think he'll get at trial? I won't necessarily address what I think the remedies he would get at trial. It's very difficult to see how this is going to play out. My sense, however, is this. Whilst there is certainly a temporary impossibility, whilst it is where there are no events going on at the moment, and potentially for a period of time, remember, the court will want to very narrowly interpret or give relief to termination of a contract. And if things do start to open up, then all of a sudden the purpose for which the contract was entered, in this case, a van, in order to, let me go back to the question, but it was a van that was going to, service venues, a food truck essentially. Well, short term, it may not be ideal for them, and it certainly is not a profitable business. But longer term, when events do happen and you expect a flood of people to go to events, I think there's going to be a very good argument from the other side to say this was temporary. Rescission is perhaps too extreme a contract. Now, with that being said, it depends how long events are going to be held off for. We're already hearing that they're being pushed back to next year. So potentially an argument of a full year being long enough of it being impossible for the person to use it and that purpose really being known. So I think a good argument on both sides. So it could be a really interesting one.
I'll answer two. I saw on there. First, Michelle, you asked, could you have frustration of purpose language put into a contract? You can negotiate anything you want into a contract. So yes, absolutely. To answer that question, it will not prevent you from going through the court system though, right? Because people can argue.
Sue for anything.
Yeah, they can sue for anything. And they can say that the purpose wasn't frustrated, right? So yes, though, you can put that into a contract and you're welcome to negotiate a clause like that into the contract. And then Peggy had a question. So you represented the buyer, you removed contingencies on March 30th, the lender gave the okay. At the end of the day, the COVID overlay restrictions on jumbo loans, the buyer didn't qualify. No, there's nothing the buyer can't do to not lose their deposit. You might have some damages against the lender that told you were approved to close. That's something to think about and consider, and your damages would probably be whatever your deposit was. The other thing is while I said the jumbo market has all but disappeared, there are one or two lenders that are doing jumbo loans. So if you message after this, I will happily make an introduction to a lender that is still doing jumbo loans. So the ultimate solution might be we can get your buyer qualified, they can still close and buy the house, and they will be happy, and everybody will still be happy.
Yeah, great. Thanks for that. We have two others which sort of are tied into the same situation. One about impossibility, both related to the wedding type situation. You know, it's summer, it's coming to summer, people have got weddings planned and so on. We have family members that had weddings planned. And all of a sudden, because of this shelter in place orders, they're not going to be able to hold their event, and it's very clearly known. So let's talk at the instance where clearly known that this was a wedding where you expected 200 plus people. Not sure if that was an Indian wedding, but certainly it'd probably be 300 or 400 people. And you know, you have that sort of a contract. Gatherings are prohibited. There is no force majeure provision in the contract. The contract says a fee is non-refundable. What's likely to be the best argument? I would very much say that impossibility. I don't want to say that. I would say there is both a frustration of purpose and impossibility, because certainly they could still technically get married, but the idea was that they would be able to get married and have a number of people there, and it was expected that they have these people there, and that now can't be achieved. With that being the case, so I'm not so concerned about the non-refundability of it, but I think there are certainly arguments to say that we need to cancel the wedding contract. We have done that successfully for 2 or 3 family weddings that have happened or were supposed to happen. So we have seen that happen. Though technically, of course, people could get married because they could just still go and have the 2 of them do the justice of peace thing. So you could still perform on the contract, but you can't host this event. So there is a purpose there, right? So that's for that. And somewhat similar, they are going to do the justice of the peace wedding. The venue is saying that they could book for the following year, but now the prices are much higher the following year. Impracticability could be a reason. Now it's so overly burdensome for them to push this off to the following year, where the expenses are going to be much higher. We'd expect air travel and so on to get expensive when it's back online. Events are going to be fully booked. There are already events booked for next year. Now you're trying to cram those in. So you can imagine it getting very expensive for people. So I think impracticability could be an argument there because of the substantial burden that would be placed on the person for those 2 questions. Jason, I don't know if you've got any thoughts on it.
You hit the nail on the head. I also think there's no guarantee that like everything's getting pushed to next year, but should something happen, there's no guarantee that they can perform next year either, if you're making the argument to cancel. So
Great. And again, thank you everyone for joining us. Sorry, we did run over. We did want to try and capture everything for you. The slides are going to be circulated, and to the extent we can circulate answers to the FAQs, we will do that. But Aoni and CB team will hand over to you, and thank you very much for allowing Jason and I to be on and part of this.